Okay, welcome everyone. Get you guys up and alive. Everyone have coffee? All right, my name is Barry Miller. I'm president and closing agent, also attorney. Thank you for coming. This is my favorite class, by the way. This is contracts. This is where everything happens. This is where the good happens, and this is where the really bad happens. So after today, you're going to learn how, when you get through all of this, there will be no bad. It'll be easy to get through, and you can maneuver through this because this is where all the problems come through. So we're doing something a little bit different. First, make sure for those of you who haven't attended and those out in the branch, go to the App Store to Poll Everywhere. It's on the side here on the walls too. Poll Everywhere, download the app. And then when you go in there, it's TCAU, the Closing Agent University, TCAU. And that way you can participate in the polling questions. And if everyone will download that in there. Now, the other interesting thing that we did for technology is we now, from downtown here, because we got the 4 other branches that are on there, we can now see them. There we go. Everyone wave. Good. So we got everyone at Altamont up there. I see Madden up there and there. We got everyone at a POE in the conference room. Let's see down there. Celebration. Hello, Celebration, everyone down there. And Winter Park. All right. Looks like everyone's getting well settled.
I said he's going to be here.
All right, awesome. And that way, when we get to the question period, they can participate also, and we'll be able to see them on there. Okay. All right, so make sure everyone goes and downloads the app. All right, the other thing I want to do is, before we get started, is one of the things that we built this company on, and is a very different theory to make it different than other title companies, is we're backed by lawyers, and we are lawyers. And a lot of companies are not, because this is so integrated. And one of the parts of our service that we feel is part of it, if you are a customer and you have quick legal questions, you don't get charged for it. It's part of the service. So if you're writing up an addendum and have a question, you can email it to us. We'll help you write it. So I wanted to introduce to you the other 2 attorneys that are part of Barry Miller Law, David Berman. And so everyone can see, just come up here, guys, for a second, so everyone in the branches can see, because some of them have talked to you guys and then haven't seen you. Look at them, they got jackets on. They look like real lawyers. And Robert Garcia is a new attorney with our office, also bilingual for anyone that has customers that speak Spanish. So whether you need something for probate or contract drafting, for residential, commercial, litigation, anything real estate, we do everything A to Z for real estate, whether it's you got clients doing real estate development, we're doing several large subdivisions, whether you have a listing that involves a probate, anything in real estate, we can help you. Don't hesitate, give us a call, email us is the best thing. We'll get back to you and try to make your transaction as smooth as possible. So I just want to introduce them, part of the great team that we have. Thanks. All right, so let's get into this contract stuff. All right, let's test your make sure everyone's on there. And what year was the original Wizard of Oz released? Vote now. Who, I don't know, it's trending up, right? Switching. Lock in your votes. D is correct, 1939, believe it or not. And later on, they colorized it. Of course, after she gets into Oz. All right, so first off, what is a contract? Simple. It's a promise or a set of promises for the breach of which the law gives a remedy, or the performance of which the law in some way recognizes a duty. So in real estate, we have multiple promises. Not only are you going to purchase, but there's all kinds of things. Every single term in there is a different promise that is either got to be kept, broken, modified, or everyone fights about it. Oops. All right, so to have a contract, you have to have certain requirements. So to be valid, you have three elements. You have to have an offer, an acceptance, and valid consideration. So you always got to have that. So first question, just by maybe show of hands on here. If the buyer enters into a contract and let's say let's say where it says the deposit, let's say the buyer says, I don't want to put a deposit down. And the seller says, it's okay. You're a good guy. I believe you. You're going to buy my house. Do you have due consideration if you have no deposit? Do you have a valid contract? How many say, yes, we're good to go? Raise your hand. David, can we put the branches on too? How many say yes, we got a good contract? How many say no? Okay, the yeses have it, all right? So one of the big misconceptions is, oh, they didn't put down the deposit. We don't have a valid contract. Well, first of all, you can never say that, right? You will never give that opinion, right? Well, you look confused. Why would you say that? Would you ever say, did you vote yes or no?
I voted no.
That we don't have one. Okay. And why do you say that? Because they didn't give any money. But remember, you have to have consideration. The consideration is also, part of that is the promise. I promise to buy it. So you do have consideration. So the courts have said, even though you don't have money, consideration can be something else. Okay. Now, the other reason is you would never say, I have a valid contract, is if you say, any of you here, unless, well, may I ask you something? You remember the Florida bar? Okay. So I just want to make sure. Because if you're not, then you have just committed a felony. Do you know that? It's called UPL. And unfortunately, realtors do it all the time. It's unlicensed practice of law. You can never give a legal opinion. You can never say, that's a valid contract, because that's a legal opinion. You're not qualified to do that. You have to be a member of the bar to do that. And by the way, we'll get into this a little bit. Realtors are getting whacked for this all the time now because they're, and I'll tell you a story later on that just happened the other day. So you have valid consideration. Consideration can be a promise. Okay, so words or actions which display the intent of a person to be bound, the offer, to be bound contractually. Now, here's the big thing, especially in today's market. They can be revoked before acceptance. Okay, now this is very, very important, because in today's market, where it's a seller's market, and sometimes you get multiples, or you may get one offer, put it on there. Let's say you're selling a house for $350. It's great. You get an offer in for $350. The other agent calls you up, says, I'm putting the offer for $350. You're going to go, oh, that's fantastic. That's great. Asking price, well, that's great. I can't wait to work with you. You present it to your client, and then in the meantime, you get one for $355. Okay, until it gets in, let's say that offer goes in at well, let's change the scenario a little bit. So you be the listing agent. I put in an offer at $350. It's a full price offer. Let's say it's even over. Let's say it was $350. I offer $355. Send you the contract. My client calls me up and says, Barry, forget it. I found the other house that's the dream house, not this one. So that's all I have to do, is send him an email that says, my offer is hereby revoked. It's done. Okay. So that happens a lot with people looking at multiple properties today. Now, on the same token, the seller can, if they don't want it, they can counter it back, and that will be your counter offer. So the offer is, you have to have an intent to be bound. Obvious, if you sign the contract, you are. Identifiable subject matter. That's easy. We identify the property. The value of the offer, that's our price, so that's good. valid parties, which we're going to get into in a minute. We've got to make sure you know who you're dealing with, and any other necessary terms. How are you going to pay for this? Dollars, euros, or now here's the new thing, Bitcoin. Has anyone been approached by anyone that says they'd like to buy real property using their Bitcoin? Anybody? Good. By the way, if you want to buy with Bitcoin, we can accommodate the sale. All right? Things can be done. Now, there's two ways you got to do that. If let's say I'm the seller and you're the buyer and you've got your Bitcoin. So what's going to happen is, and if you're the buyer with Bitcoin, like you said, so as the seller, we would go to the seller and say, the buyer wants to pay in Bitcoin. You have the option, do you want to be paid in Bitcoin or do you want to be paid in dollars? Now, if they want to be paid in Bitcoin, it's much easier. So we can just facilitate a transaction. But let's say I'm the seller and say, I don't know what this Bitcoin thing is. I don't like that. I want to be paid in dollars. We can still accommodate it. So what we do is we have an intermediary that you will send your Bitcoin to my intermediary 48 hours before closing. Then our intermediary will convert it into dollars and then wire it to me, and then we will pay the seller in dollars. So Bitcoin will be more and more and more, or these other currencies, cryptocurrencies. I was just told that Seminole County now is going to be accepting payments in Bitcoin.
Is there a fee for that process?
Yes. I think the intermediary charges, I think it's like 3 or 4%. So, but all these cryptocurrencies are coming around. They're going to be there. It's going to be very interesting when the economy has a correction, whether this becomes more prevalent or not. All right, so contract formation, the offer. I, Jane Doe, hereby offer to sell you, Sally Johnson, my home located at 11 North Summerlin in exchange for $125,000. We have an offer. Now we have to have the acceptance. So the opposing party has to agree to the offer. Once it's accepted, the contract's complete, provided you've got your consideration. So we said the promise is enough for the consideration. The big thing is the mirror image rule. In order to have an acceptance, to create it and to make it valid, it has to mirror each other. So otherwise, if it doesn't mirror, it's considered a counteroffer. Now, this is what happens in real life. It comes back and everyone plays the gotcha game. Everyone's been at it, right? The other side, gotcha. Oh, we don't have it. Here's in this scenario. I give you the contract, you send it back, there's some changes, my person does an initial one thing, and this happens all the time. The realtor goes, oh, we don't have a valid contract. Give us our deposit back because your client never initialed the bottom of page 3, or they never initialed where we changed the deposit from $3,000 to $5,000. Therefore, we don't have a contract. Okay, question on the initials is, if you forgot an initial, do you have a valid contract or a counteroffer? How many say you have a valid contract? Raise your hand. How many say you don't have a valid contract? You got to vote. Raise your hands, folks. Can we put up everyone, David, can we put up this? All right, how many say you have a valid contract? Okay, how many say no valid contract? Okay, I'm going to give you the lawyer answer. It depends, okay? Generally, you do have a valid contract. Just because a court is not going to sit there if it's an inadvertence of that. Like, for example, what I just used, it was offer and counteroffer, 3,000 deposit changed to 5,000. They forgot to initial it. The court would go, wait a minute, did you send in the 3,000 or the 5,000 with it? They go, we sent the 5,000. The judge is going to go, no. Just because they forgot to initial it from 3 to 5, but they sent the 5 in, you have a valid contract. If it's something minor and the court says you have a meeting of the minds, it's going to enforce it. So I have all the time, and again, the realtor goes, oh, they didn't initial it, don't have a valid contract. I go, where'd you get your law degree from? Freck. No, can't get one from there yet. So you can't. So you got to be real careful on that stuff. So it's great. You remember, it's generally a meeting of the minds. So minor things like that, the courts will overlook. All right, so then if you have the counter, I, Sally Johnson, hereby accept your offer and agree to purchase your home for 125. The counter would be you come back and say 115. So we have no contract formed, and that is just a counter offer. So the value to be transferred between the parties for consideration, as we said, it can be a gratuitous promise. So you can have a promise. I promise to fix your mailbox for $50. Consideration. Performance. If you actually fixed the mailbox, you did it. Forbearance. Refraining from doing something which has a legal right to do. I promise to pay you $5,000 if you stop smoking for 1 year. Consideration. And if you have some sort of consideration, can be a legal relationship. So marriage, corporation, operating agreements, things like that. So it doesn't always have to be money. All right. So, some people are answering quick. Which of the following scenarios is a contract created? A to B. I will paint your house for $25. B to A. I'll do it for 15. A to B. I'll paint your house for 25. No thanks. C. Would you be interested in letting me paint your house for 25? Yes. Or D. I will paint your house for 25. Great. Please paint my house for 25. I'm a little conservative. All right, you guys got it. D. Why isn't C right? Anybody? Why do you think C is not right?
Because of year.
Sure it is. $25. Yes.
Doesn't state what you do. Not a mirror image.
No, it is. Would you be interested in letting me paint your house for 25? Yes. I will paint your house for 25. All right. Would you be interested? Didn't say I'll do it. So what if he says I'd be interested? Yes. So B says yes, I'm interested, and A said, well, how interested are you? Are you really interested? So okay, so it's interested, so it's more, it's not definitive. So D is the best answer. All right, the biggest thing that we deal with is statute of frauds. All right, so on our painting house scenario, it was verbal. So guys, verbal contracts generally under the law are enforceable. I promise to paint your house, or I will promise to pay for $25. Yes, here's a check. Or just says yes. It's oral. It is enforceable. However, it's changed by statute. And Florida has the statute of frauds, chapter 689.01. No estate or interest in freehold or for a term more than 1 year or any uncertain interest of, in or out of any lands, tenements, or hereditaments shall be created, made, granted, transferred, or released in any other manner by other than by instrument in writing signed in the presence of 2 subscribing witnesses by the party creating, making, granting, conveying, transferring, or releasing such estate. Wow, that's a lot of gobbledygook, right? Well, that's what lawyers do and the legislature does. So the bottom line of this is all real estate, any contracts for land, real estate must be in writing. Okay, so what about this 2 witness thing? How many people have 2 witnesses on a contract? Nobody. Okay, so you don't have to. What it is what it says is if you have an agreement for a term more than a year. Now, let's say we entered into an agreement and it says, let's say we do an agreement and I'm going to purchase your home, but I'm going to purchase it in November of 2019. Then you need 2 witnesses to make it valid. Okay? Leases. If you have a lease for more than 1 year, you have to have 2 witnesses. Otherwise, it's not valid. So any contract, you got to remember to do that. That's why we don't have it on generally on the FAR bar, because it's very unusual. When we do lease options or lease purchases, they usually take more than a year. We make sure we have 2 witnesses. People send them back, no witnesses. I go, where's the witnesses? The realtor says, well, you don't need that. I say to that realtor, where do you get your law degree from? Put the witnesses on. So you got to make sure you do that, because there has been times. Now, why does the legislature do that? Land's important, land's complicated. The law says it should be in writing because there's too many moving parts, and it reduces litigation if you require it to be in writing. All right, capacity. This is coming up more and more and more, especially because our society is getting older. The baby boomers are retiring. So you have to make sure it is. Now, first of all, obviously, they have to be over 18. Got to. It is avoidable contract. The other thing is, my recommendation is never put property in a minor's name. Why? I had this happen to me several years ago. Properties in the minor's name were at closing. I'm sitting there. I said, I thought it was a husband and wife. And I said, oh, ma'am, where's your husband? She starts crying. He died. And I said, oh, sorry, we'll need a death certificate to record because his name's on the deed. And she goes, oh, that's not my husband. I said, who is it? She goes, that's my son. And I said, oh, okay. Well, we need him to come by and sign. And she says, oh, okay. Well, he's right up the street at Olympia High School. I'm like, please tell me he's 18. She says, no, he's 15. I'm like, well, we can't have a closing today. A lot of people say, oh, I can just sign for my minor child. False. You cannot. So that closing got delayed for 6 months. The judge made them have an appraisal and then made the mother put half the proceeds in a trust account for the benefit of the child. My opinion is you never, ever put property in a minor's name. It's just a disaster. Mentally competent, back to second, intoxicated, don't ever drink. Have the drinks after, not before. By the way, there's a title company in town here that serves cocktails during the closing. They're insane. They're insane. It's gonna come back and bite them.
So if you do have a minor, what's the best way to say that?
If you have a minor, the best way is to put it into a trust. Yeah, absolutely put it into a trust. Now, guardianship and competency. All right, so what's happening these days, folks, is, Alzheimer's is a horrible, horrible disease. It's affecting a lot of people. But you've got to be careful when you're doing a listing agreement and when it comes down to sale. So if you're in there doing a listing agreement and the husband says, you need to come in the morning because my wife is good in the morning, that's when we'll sign the papers. What do you mean she's good in the morning? Well, she's got the early stages of Alzheimer's. Okay? And you're like, oh, it doesn't matter. It's the wife, Let me tell you what happened. We had this happen once. They did that same scenario, came down to closing, and 4 days before closing, this was a second marriage. The children of the husband came forth and said, whoa, 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 wait a minute, what is going on here? We're not selling this property. We don't want the property sold. So the children get involved and they say she wasn't competent to sign, or they want to know what's going to happen with the money. So you've got to be really careful. When everyone says that, you got to get a doctor's letter saying the person is competent. Or the worst thing is the realtor calls up and said, will you do a power of attorney for us for the wife to sign because she has Alzheimer's? No. We have a situation now where we did a trust for someone. I don't think she's competent. We prepared it. I won't let her sign it until she gets a doctor's certificate. It's been 3 months. And I think she can't get a doctor because I don't think she is. So you've got to be. Now, what happens when this scenario, and then the doctor says, no, she's not competent. She can't sign a POA. What are you going to do? How do you sign the property? How do you sell it? Guardianship. So what's going to have to happen, and it takes several months to do this, that usually the husband will be appointed as the guardian by the court, have a court order so they can sign everything. It's not that complicated, but it's got to be done. So just be aware of that. And that's why we tell everybody, get powers of attorney, do your wills, get everything together. before you get too old or something happens to you. The other thing that's important too is the healthcare surrogate, because if someone can't make their own decisions, and it's part of that package. Okay. To be bound, what happens when you have a buyer or seller that is a corporation, LLC, or a trust? All right, so for a corporation, the offeror or the offeree must be an executive or person duly authorized. You got to get a certificate of authority. So LLC, same thing. Trust, you have to know. All right, so let's talk practical. If you've got a seller and they're one of these, first, if it's the first two, you go to Sunbiz. You see what's on there. Question, what happens if it says on Sunbiz, ABC Inc., administratively dissolved September 23rd, 2016? Can you list the property and can it be sold? How many say yes? You can take that listing. How many say no? The answer is yes. Okay? So just because it's dissolved, that's why you come to these, now you know. All right, the reason why, logic will tell you no, it's dissolved, but the legislature has a specific statute that even though they are dissolved, as part of winding up of the corporation, they can dispose of their assets. So what we do is we put on there ABC Inc., a Florida dissolved corporation, and they can still do it, or LLC. Now, next question. You go in to do the listing, and guy introduces himself. He's the vice president in charge of operations, and he's going to be one that's going to coordinate all this with the company. He'll be your contact person, and he'll be signing the contract and all of the documents for closing. Everyone good with that? He's the vice president? Good? Yeah?
Does he have the authority?
Yep. No, no good. Okay? Under Florida law, the president has the authority to sign. So it's the president that shows on Sunbiz. Our little clip on here is breaking. Okay, let me know if it falls again. All right, so under Florida law, a president is assumed to be. So if you go in, he's the president, you're good. If it's anybody else, you have to have a corporate resolution saying they had a meeting of the board of directors, the shareholders, and so vice president is hereby appointed, and then you're okay, right? Now, on the LLC, it becomes a little trickier. If you go to Sunbiz and there's one manager, he or she signing, you're good. Manager's assumed. Now, what do you do if there's two managers? So both have to sign. The answer is maybe. Okay? So what if they sell you, say, well, I'm the manager and she's the manager, but she's my principal and she's in Beijing. Good. So you got to look at the operating agreement. Well, you really can't look at it and make that legal determination because you're not licensed. So what we do is we look at the operating agreement, and then what we see is and see if they have the authority to do it. Because sometimes it will say the managers have to act jointly. Then I have to have both. If it says they can act individually, then we're fine. Then we also have to look and see whether the manager has the authority to sell real property. Or sometimes it says that it puts a cap on what they can do. Like a lot of times when we do operating agreements, it says the manager can conduct any transaction under $50,000. Otherwise, it needs the members' approval. So you got to be careful. This actually happened with an agent 7 months ago. Two managers. Guy here locally sold, everything's fine. We go to closing, we get the operating agreement, needs both. We say, who's the other manager? Or we know who it is. How do we contact him? We contact him. He goes, what sale? What are you talking about? We're going, the sale of the building or the business, you're the manager? I know nothing about it. Well, you're the manager of the company. He goes, yeah, I'm the investor. I put all the money up, so I wanted my name on as manager. and I don't know anything about this. The agent calls the other guy and goes, what's going on? He goes, well, it's my business. I'm selling the property on that. He goes, well, it's not your business. He's got to agree. And he goes, I'm not agreeing. So that agent wasted all their time and effort on marketing the property, getting under contract, because the investor up there was like, no, I don't think it's a good time to sell. And of course, they got into a whole battle. So you got to be really, really careful. Trusts, all right? We got to look at the trust, see what the trustee's authority is. Now, let's say you have the Miller Family Trust dated January 1st, 2017. You can't put that on as the seller or the buyer. It has to be the name of the person, Barry Miller, as trustee of the Miller Family Trust dated. You've got to do that because a trust technically cannot be titled in property. It's the trustee as on there. So all of them have got to be there. Then you got to see it. Then what typically happens is if on the deed you see the person's the trustee, you meet the trustee, great, that's fine. We're still going to need a copy of the trust. But let's say you go in and it has John Smith as trustee. When you go there, the wife says, oh, well, John had passed away. I'm the successor trustee. We got to look at it and make sure that is the successor trustee. And then sometimes the successor trustee may have a co-trustee. So we just had one recently, which I don't know why the guy did this, but he put on there that the beneficiaries had to approve the sale. All right, not so bad. Well, the beneficiaries were 5 beneficiaries, and they're all minors. They're all minors. What did we just tell you about minors? They can't make decisions. So they could approve the sale, but it's not binding. What do? 3 title companies told the people, you got to go and do a guardianship, not 1 guardianship, 5 guardianships. And by the way, the couple's in a divorce. They hate each other. They have kids. It's a mess. My new clip. If it falls. So she's like, so this woman called me up and she goes, oh, actually it was another attorney. It was the divorce attorney that I met at a conference. And I said, oh, we like challenges. So she calls me up and she goes, oh, I got one for you. She goes, Fidelity turned it down, First American turned it down, and some other agency turned it down. They said, oh, you got to go to court. We can't do it. So I said, well, oh, and by the way, the guy recorded the trust. You never record trusts because it's private. So I can tell you something, we closed it, no guardianship. So what we did is we looked at it and analyzed it and said, all right, what's going on here? How much it is, we did a little pro forma on it. So as it turns out with the net proceeds, there's a statute out there that a lot of people don't know about that says that if the amount that the minor is going to get is less than $10,000, the natural parents can sign for them because the legislature thought for minor things under $10,000, you shouldn't have to open up a guardianship that could cost $5,000. So we ran the numbers and the percentages. It turned out that the oldest son was getting more and he was getting, I think it was like $13,500. So they said, we can't do it. And I said, I don't like the word can't. I said to the attorney, I said, have you gotten paid? She goes, no. I said, I bet you're getting paid from the money from the closing. She goes, oh yeah. I said, I know you want this thing to close. I said, you owed more than $3,500? She goes, oh yeah, a lot. So I said, well, we'll just put it on since all the parties are going to agree, put your fee on the closing statement, then that minors would bring it down under the $10,000. We're done, we close. And we closed the thing. So sometimes if there's a will, there's a way. We just got to find and get creative in doing it. But you've got to be careful with who you're dealing with. And then the other scenario that happens a lot with the trust, I can't find the trust. I don't know how it can happen. We just had one recently. They couldn't find the trust. Oh, great. Let's just call the attorney. Call the attorney. He's dead. Great. So, all right, his partner was still open. Luckily, it was in some deep, dark cave somewhere in their warehouse. They found it. So, but sometimes you can't. But you've got to always get your ducks in a row ahead of time. So know who you're dealing with. Make sure it's right, because it can be costly and you can waste a lot of time. All right. So let's talk about the contract. So what do we have? We've got the as is. I call it the regular contract. We got the FAR commercial contract, and then we have, actually, this is actually incorrect. This is, it's just a FAR vacant contract. So the reason why a lot of people keep referring it to the FAR bar commercial contract, it's not. The bar has not endorsed it because the bar thinks that you should have attorneys do commercial contracts. I'll be honest with you, I use the FAR commercial contract a lot because I think for small deals it's good. We just write up extra language for it. All right, we all know that 99% of everything happens on an as is. I just have to preface in saying this. Why is it on it using an as is? Because it's a seller's market. All right, now if I was taking a listing, I would explain this all to my client, and I would have on the bottom of my listing agreement, standard language, all offers will only be accepted on a FAR bar as is 4-17. Yeah, 4-17. Because that way, if someone gives you a regular contract or something else, you don't have to present it. All right, because the law says you have to present all offers. However, if you put that in your listing agreement, you don't have to. And it stops the other side from doing it. I had one just yesterday. They took the FAR bar, left off the complete back page, changed it. That's all they did is they bastardized it. And it's a one-page FAR bar. But there's a copyright violation there, and it was crazy. People do it. I had one the other day. I had one 6 months ago that a commercial contract, $2 million deal, they used a FAR bar from 1997. And I said, and then they had a 8-page addendum. I said, can we just trash this thing and start over and do it real? And the other side said, no, we've already put the time into it. I said I wanted to say to the other attorney, you obviously don't do real estate, because no one in their right mind would ever do that. Now, if you're a buyer, you want to use the regular contract. Why? It's got two big protections in there that we'll get to. One is the automatic repair, termite and permits. And the other thing is the obligation under that permit, which we'll get into. But realistically, is anyone using the regular contract? Oh, all right, where's my clip? When in doubt, binder clips. All right. All right. You guys have got to be careful doing this. I had an agent that took a commercial contract, took a vacant land contract. It was for almost $1 million. 80% of the blanks were left blank. Now on the FAR bar, the bar and the realtors got together and pretty much said, every blank that's there, in case you don't fill it out, we're going to put if blank it is. Commercial, they don't do that. And I was like, what are you doing here? 80% of it's blank. I don't think we have a real contract. Oh, can you do it for me? I was like, well, I get half the commission? No, I said, you need to do your job. Go back and do it. I can't, you got to go sit with your client, ask the questions, fill it out and do it. So be real careful when you're filling it out. Be careful of the language you use. Never use the word may, use the word shall. The seller shall convey. The seller shall repair. Never use the word request. Seller may elect to terminate this contract. Use shall or shall terminate it. See, under option 1, the seller has the right to. On the number 2, they must. So don't be afraid to use definitive language. All right. The other thing is using terms. You got to be careful. It's what we call, the law says, it's got to be unambiguous. What does that mean? Be clear. So you've got to do it, because if you don't know, then a judge is going to have to decide, and you don't know which way it was. Okay, here's an example. Seller shall repair all items around the home. By the way, this is from actual contracts. Seller shall repair all items around the home. Okay, does that mean seller repair the exterior, the outside, the inside? What does it mean? When a particular premise is described in the contract spans multiple plats, so you've got to make sure everything's in there. One of the big things too is, by the way, that I see is with condos, make sure parking and storage spaces, 99% of the time they are not included in the legal description. So you've got to do two things: add in under the legal or under the personal property. Seller shall convey parking space 1, 2, 3, and 5, 6, 7, storage unit space, whatever it is. Then don't presume, because 99% of the title companies won't do the paperwork for you. They'll say that's not our job. You've got to find out from the association. What you should do is find out whether they have a prescribed form that they require, or if not, some title companies refuse to do it, then you have to have counsel. You cannot draft those forms. Don't do it. If you do it, it's do not pass go. Don't collect 200. You get fined 50,000 for practicing law. So you can't take forms that you find on the computer or on the internet, and what I call, change them up, change out I just changed the names in it. That's practicing law. You're up there, yeah.
But if it's on the condo rider, the parking space number.
If you have it on there, right? Yes, if you have it on there, but yeah, you can put it on there too. I like putting it in the contract because it's just clear up front. Because a lot of them, like for example, Park North and Uptown, they are deeded. Because when I created those, I wrote those condo docs for both of those. So when I think the better way to do it is Unit 102, Park North, recorded and plot, and parking space number 1, 2, 3, and 4, 5, 6. It's part of your legal description. It's in the property appraisers. It's there. It's on public record. On the other ones, it's just in the books of the condo. So we had a problem over here on Star Tower where someone used 2 parking spaces for 15 years. He never lived in it. He rented it out. His leases had to be approved by the management. Every lease had both parking spaces. They always approved it. And then a developer who came in and took over from the bankruptcy estate from the developer came in and said, oh no, you only get one. Look at the declaration. You only get 1 space. We're taking the other one back. We even showed in the MLS where it had, when he bought it from the developer, the original developer, it had 2 spaces. I told him to fight. We'll win in court. He decided not to. When he sold his unit, he had to reduce his price by $20,000 to make up for the space. So you got, those spaces are very important, and they keep coming up. All right. So your parties, obviously seller. And you guys have heard me this before. When you take a listing or when you're doing a contract on the buyer side, go to the property appraiser, look up the property. Do not use the names or the legal description on the property appraiser. They have about a 35% error rate, 35%. What do? You go to the sales button, every county has it, see where the last deed was, click the hyperlink, then it'll take you right into the deed. Look at the deed, either print it out for your file or put it in your electronic file. Use the names of the spelling if you're a buyer. Don't ever put owner of record. The only time you have to do that is if you're buying an REO and the seller in the MLS says to put it there because they're so screwed up they don't even know who owns the property, the banks. But put whatever it is on there. Now, let's say you pull it up and it says John Doe, trustee of the Doe family trust, but in the listing agreement it says Mary Doe. Well, you're going to call the listing agent and say, hey, I'm confused. The deed says John, but you put Mary. Oh, John died, Mary's the successor. So then it would be Mary Doe as successor trustee of the Doe Family Trust. All right, so you do that. So make sure your parties are correct. Your buyer, ask your buyers for their driver's license. Should be part of your file, because you want to make sure their name is spelled correctly, and people use other names, or what are their legal names. So you want to make sure you do that. And just for security purposes, before you take somebody out, you want to get their driver's license and know who they are. Whoa. Maybe that will help it. All right, street address, you always want to put in your county, your tax ID number. Okay, legal, again, don't take the legal from the property appraiser, especially if it's meets and bounds. Because if it's meets and bounds, there's about a 65% error rate. I had one of my friends got divorced, and he had his divorce attorney do the quitclaim deed between the husband and wife. And he went to do refinance 4 years later. And what did the divorce lawyer do? Cut and pasted the legal description from the property appraiser. Well, it's about a 20-line meets and bounds. Well, you know, the property appraiser has the first 3 lines on it. He did not have good title to his property. Had to go back to the ex, have a corrective deed signed, and guess what she said? For $10,000, I'll be glad to sign it. 10,000. She goes, what am I going to do? I said, tell your attorney to pay her the 10 grand. He screwed it up. It was a mess. It messed up his refi, caused all kinds of problems. Again, take it right from the deed. And if it's way too long, like meets and bounds, see Exhibit A. Cut and paste the legal right off the deed onto an Exhibit A. You're done. You're not going to have a problem. Let me tell you, this happened to somebody recently. They took it off property appraiser. We get to closing. The buyer, we have a survey done. The buyer says, where's the other lot? We go, what other lot? Well, there's supposed to be 2 lots with this. And they cut and pasted. Seller was a smart guy. He goes, oh, you want that other lot? Oh, well, that's going to be an extra $62,000. He goes, no, it's part of it. And the listing agent says, no, the listing had both of it in there. And the guy says, yeah, but your contract's a contract. You put in only the 1 lot. I thought I was getting a great deal and I have the other lot to sell. The listing agent goes, no. The seller said, you work for me. You better keep your mouth shut. Well, that was a mess. Mess.
That's a big mess.
Huh?
That's a big mess.
That's a big mess. So guess who the buyer pointed the finger at? Buyer's agent, because they messed it up, because they did it. So the buyer's agent ended up having to forego their commission. They used it towards the extra money that the seller wanted. So again, take it off the deed. It's the safe. You know, it's like take it from the source. Okay. All right, personal property. I personally don't like the way they have this. It says, which are owned by the seller and existing on the property the date of the initial offer. Now, luckily, we don't have a lot of problems with this because people don't. But you know, during the recession, people were having a problem. They were switching out appliances and stuff. As a buyer's agent, I would go in and take pictures or a little video of what's there just to make sure things don't get switched out of what, and make sure the things that are there. Make sure to exclude stuff. All right, because the way this is, if it's not excluded, if your seller says, oh, those are my grandmother's drapes on there and I want to take them with them, you better make sure it's excluded. Otherwise, you're going to have that fight. So be careful of those items.
So the microwave is not there.
Microwave is built in. So anything, okay, so that's a good point. Anything that's attached, hot water heaters, I have people, agents, I'm going to write the hot water heater in. You can, there's no harm. You don't. The rule is if it's attached, it becomes part of the real estate. Question then. Stove. Is a stove part of the real estate, or you get list it separate?
Yeah, I'll consider it part of the real estate because it's attached.
Sorry?
I would consider it part of the real estate.
Okay, the answer is maybe. It depends on what kind of stove you have. If you have a slide-in stove and you plug it in, it's not part of the real property. It's not attached. But if you have one of those cooktops that gets, the cooktop or the wall oven, that's attached. So it is. So the rule is attached, it's with it. So maybe. All right, personal property. Now, here's the other thing. People don't realize in the FAR bar, it says not once, but twice. The seller shall give you a bill of sale. We're like the only title company that does it automatically because the deed gives you title to the real estate. The bill of sale gives you title to the personal property. We have had situations before, especially during the recession, where the buyer gets a week after closing and either Sears comes and picks up the appliances because under the Sears and a lot of credit card agreements, it says title does not pass until they pay their credit card bill. Therefore, Sears still has a security interest. They can take it. Or a neighbor let them use something, the washer and dryer, come to get it back. Now, this buyer would have no recourse against the seller without that bill of sale. So it's so important to have it. And again, it's required by the contract. Gosh, that's what it is. There's a 2-second delay. All right, on here, your purchase price. Do not ever put TBD. If you are a seller and someone brings this to you, an offer, do not let your seller sign it TBD. You are negligent if you do that. So when it turns out later there was no deposit made and and the buyer says, well, it said TBD. No one told me who to make the check out to, so I didn't. They're going to point fingers at you. When you see an agent put TBD, they're lazy. Put it in there. Fill it out, know where it's going. You've got to know where your deposit's going. The other thing is, why is everyone afraid to use additional deposits? Today, things are crazy. Let me tell you, I'm getting a call at least once a week now of, mainly from buyer's agents. I just got a call from the listing agent. Seller changed their mind. They're not selling the property. I'll send you over the release. Your buyer can have their money back. Sorry. They call me up. Can they do that? They do whatever they want to do, but we can sue them for specific performance. So you can do that. But again, additional deposits, that's on the seller side. Now, if I was on the listing side in today's hot market, if they gave me an offer, first of all, you've got to get 5 or 10% down. You guys have got to stop getting this little $3,000, $4,000 deposit. Why do you do it? Anybody? Why?
Because most
If
buyers don't have that money.
Then they shouldn't be buying a house.
So they have to 3% down.
Okay, that's the key right there. When you see, if you're the listing agent and they're getting an 80% loan and they're putting 3 down, you tell your seller, I don't recommend that we take 3,000. I recommend we get 10% down. And when the buyer's agent says, well, they don't have that kind of cash. Well, they're getting an 80% loan. They're going to come to, you got to have 20% to come to closing. Oh, yeah. Okay, start thinking smarter, folks, okay? So if it's 80% financing, I would say, if it's my client, I go, I want 10% down. And at the end, start doing this if you're listing agents, because you can get away with it. At the additional deposit, at the end of the inspection period, get more money. So let's say it's a $500,000 home. I want $10,000 now, and at the end of the inspection, the buyer's agent says, "Ah, that's ridiculous. I've never." Well, never is today, right? I always tell them that never's today. and today, and you'd say, oh, you know, that's my seller's counter offer. If you don't like it, you know, I'll move on to the next 2 or 3. There's plenty of people out there looking. It's a great market to do that in. You know, when the recession comes, it'll be the other way. You know, you get away with $1,000. So ask for more, because if they default, then your seller's going to be happy. They're going to have that extra money because they're going to be mad. Going, really? So we wasted a month and a half. They walked. I'm getting $3,000. Oh, we got to start all over. But if it was, I don't care, let them walk. I just got 20 grand. Then your seller will be happy. And if you're on the buyer side, again, don't be afraid to ask your buyer when you're writing up the contract, because they're more or less likely to walk away and you'll still get your commission if they put a higher deposit down. So if on a buyer's agent standpoint, it's good business too. You got a wishy-washy buyer that wants to put $1,000 down, you're going to spend hours and hours, and then they may walk away, and then they go, oh, come on, we got rid of that one. Let's go look at another property. Let's go look at more properties. You're going to show them another 25? You'll be working for about $2.25 an hour by the time you're done with them. So get higher deposits. Financing, whoops. Are you doing that now? Oh, now he's messing with me. You do it from now on. Whoop, go back. Again, don't put 80%, put the number there, and don't put balance, put the dollar amount there. It's always better. We all have calculators on our phones and everything else. Okay, next slide. All right, this is often overlooked, because when you go back and forth, don't forget to update this date. Because if it says the buyer and the seller executed, delivered copies on or before blank, this offer shall be deemed withdrawn. Now, I've had, you know, because I always get the call, Barry, get me out of the contract. And the realtor's like, well, it had on here August 6th, and we were going back and forth, so it wasn't done until the 7th. We don't have a contract. Yeah, you do. A judge is never going to say you don't have a contract. But just be aware of that. All right, next one. Closing date. Okay. You guys have taken my class before. It's a broken record. Never, ever, ever, ever put on or before. Ever. Ever, ever. When are you going to put on or before? Never. Okay? You put the date. If the parties can do it beforehand, you do an addendum. All right? I'm not going to tell the long story, but basically I had someone put on or before. The seller wanted to get out. We wrote a letter saying we're closing next week. They said, no, we're not. We're saying, buyer, your agent wrote the contract, put on or before. You're stuck with the language. There was a lawsuit over it. All right? So you'd never want to put on or before. All right. Questions? Questions so far? Yes?
For the finances part, let's just say the buyer put down 15%, but later they change it to 20%. Do we have to go back to the contract?
Okay, so the question is, the contract had 15% down, and they're going to change it to 20% down. Well, depends on what perspective you are. If you're on the seller's side, I don't really care if you're going to put 20% down now, if it says 15. From the buyer's perspective, if I've got my loan approval, and if I have my loan approval already, I don't really care either. Yeah, there may be a certain, now if it's before loan approval and I find out that it's, oh, it's the feedback up here from, it's there. Okay, so yeah, so generally no. Okay, questions? Oh.
Yeah, question.
Sure.
Buyer's default, who's entitled to the deposit?
Well, if the buyer defaults, the seller is entitled to the deposit. You have to go to your listing. Okay, so the question is, if the buyer defaults and the seller's entitled to the deposit, does the realtor get anything? You've got to look at your listing agreement. Some listing agreements say you get 50%. Some of them change it and make it 0. So it's whatever your listing agreement says. So you got to do that. Okay, questions out in any of the branches?
Barry, we have a question in a code.
Okay.
We can hear you.
Can you hear me?
Yeah,
I was wondering, this goes back to something you were talking about before, about the trust account. If a trustee wants to purchase a property, is it better to buy it in the name of, like you said, trustee, or is it better to buy it, you know?
Only because I know what she's trying to ask.
anyone get that question?
If the trustee of the trust wants to buy a property, should they buy it as the trustee of the trust or as their individual name? She's asking.
No. I mean, the whole idea of a trust, if you've got a buyer and they're a trust and they tell you they're a trust, you should put it, that's their desire of why they want to do it is in the trust name. Just like if they said, I want you to show me property, I'm going to buy it in my LLC's name. Well, you wouldn't put the contract in their individual name, you put it in their LLC's name. So that's why when I said before, you should know who your buyer is. So if your buyer is a trustee, absolutely put it in the trust name. John Doe as trustee of the Doe Family Trust. Okay, does that answer the question?
Yeah, thank you.
All right, great. Any other questions? Yes, out in the code. I saw the hand, but.
Instead of,
Okay.
can understand that question.
Okay, does someone in Chloe in the conference room have a question?
Yes, can you hear me, Barry?
Yes.
When is the contract effective date if the 12-page contract is signed and there are some addendums still to be initialed?
Well, the effective date, and this is a good question, because if you look on here, a lot of people think the effective date is the date when the last person signs. That is incorrect. They changed the contract about 3 or 4 years ago, and now if you look on line 49, it says the effective date of this contract shall be the date when the last one of the buyer and seller has signed or initialed, but here's the kicker they added in, and delivered this offer or final counter offer. So it's when it's delivered. So if you've got initials on addendums, according to that, it's the initial on the last addendum. However, let's say through inadvertence, like I said in the very beginning, there was one initial missed. That doesn't mean that that you don't have a contract, but it could affect your date. So it is the initial, the last initial, if you're going back and forth on stuff. But it's, so let's say there was initial by a buyer today on something that was essential. Let's say it's the purchase price, and I don't send it back to the other agent till tomorrow. The effective date is tomorrow. And this is where a lot of people has got the gotcha. We're going to go into later. That's why we developed a timeline for you to use. So at the end of your contract of negotiations, when it's accepted, when you establish and both agree on an effective date, you'll do your timeline so everybody's on the same page. But that's a great question because that's coming up a lot these days when things go back and forth. But it's when it's delivered, the last initial when it's delivered. Great. What other questions? Altamont? Yep. Okay, I thought it was Altamont.
Question?
Oh,
Here's a question about saving email.
no. Can you repeat it?
So your contract effective date, you should save your emails of when you sent it. What if the agent says, I never received it?
Great question. Well, two things. One is always make sure to put your request receipt when they open it. So this happens, a great question. So the agent says, well, the effective date is not today because I never got it, right?
So it's
You can't hide things in today's digital world. The contract says delivered, not opened. So if my email shows I sent it today and shows a delivery date of today, you can say you didn't get it. It doesn't matter. As long as technology, I can prove that it was delivered, that's there. And if they go, well, you know, it went into my spam, but it doesn't say delivered outside of spam, or it doesn't say, however, if this happens to go in your spam box, you get an extra day. It's not there. So the law is when it's delivered. So if they say they didn't get it, too bad. Too bad. As long as the party can prove that it was delivered, and technology-wise, through everything through digital, it's easy to show that. Great question.
We have a CRM that we can see when they open and how many times they open and the time they open.
So that's through what?
CRM that we
Oh, through
use.
HubSpot?
Yeah.
Good. So you say you do your mail through them. Yep. Great. Yeah.
Clients and.
By the way, folks, hacking is the biggest problem right now, and they target you. How many people use Gmail, AOL, Yahoo? It's not safe. Realtors are getting hacked all the time. Make sure you turn on the two-step authentication, as most agents don't do it, but if you do it, it cuts your chances of being hacked like 90%. So we have had agents that have been gone after because they get hacked. The hackers get in there, send a fake instruction to their buyer to wire their money for closing to somewhere fake, and then they want the agent to pay. You should, some brokers, we have a disclosure that says they sign up with the listing or the buyer side that says we will never send you wire instructions. If you do, ignore them, and we will not be held liable if you follow instructions from any of our agents. You should only get them from the title company or from your lender, and then don't trust them. You should always verify them. Okay, any other questions? How's Winter Park doing there today?
Celebration has a question, Barry.
Okay.
Barry, on 15, under personal property, I've seen some real estate put in MLS number, blah blah blah, dated the date that they went there to do the inspection for the purchase. Do you recommend that or not?
No, I don't. It's okay. So question. I'll tell you why I don't recommend it. Today it says there's a Wolf refrigerator in there. Tomorrow, if I'm the listing agent, can I change that and take it out? So even though you put an MLS number in there, it can be changed. Now, some people will attach it. They'll say per MLS attached. You can do that because then it's printed out and you have a list of it. So that's okay. But don't just put it, because you can change it. I mean, the listing agent can change it in a second. So again, you don't want controversy. You don't want to get into a fight. So do it so it's definitive. Remember, we talked about definitive language. If you can change something from a third party and not know it, it doesn't become definitive. So you don't want to do that. Good question. All right. Let's.
MLS, we have no idea what is on MLS, and we're just gonna put per MLS on the bill of sale, because we don't have access to
Let's go to the next
MLS.
slide. Okay, so what we're going to do now is, because we're going to take our lunch break, but what I need everyone to do is get your food and come back up, because you're going to eat while I continue, because we've got a lot of stuff to go through. So it is 11:12, so let's come back up at, like 5 minutes. Everyone get some. Okay, talk loud so they can hear me up there too. So we can't put these on, of course, without sponsors. And we really appreciate sponsors. We have Gail here from Rental Home, talking about their referral program that they have. So take a few minutes and tell us what you do.
Thank you very much. I want to start out by thanking Janelle and Attorney Miller for affording us this opportunity to meet with everyone. As he said, we're Rental Home Management Services, Inc. We manage residential homes for investors. We focus on unfurnished long-term rentals, which means a year or longer, and many of our tenants stay over 3 years. So it saves the tenants move money, and it saves the owners get ready money. So that's what we focus on. Our mission is to minimize the stress of investment properties, so more people will be interested in being involved in that, and to make the rental and management of properties the best that it can be for them. I thought it would be apropos to talk a little bit about the contracts we use based on the content of your class today. Obviously, there's a contract, a property management service agreement between the owner of the investment property and my company, so that's contract number 1. Spells out our responsibilities, our authorities, and also responsibilities the owner has to us in providing us information. In your packet today, you have a sample management agreement that we use and also our property owner's handbook. The agreement is the contractual agreement. The handbook is a better explanation of what we do and how we do it. And it also includes a list of what's included in our fees, which is quite extensive for them. The second contract then is the lease. The lease agreement is between the tenant and the owner of the property or the management company, depending on how they sign their leases. This document provides the tenant with 3 of the 4 rights of ownership. And this is, we all know the 4 rights of ownership, right? Their possession, you can occupy it or you can assign the occupancy to a tenant. You have use. You have the right to use the property for a legal purpose and within zoning restrictions. You have the right of exclusion. This is one a lot of people don't realize. A tenant actually has the right to tell you they would prefer you not be on their property. The 4th right of ownership is disposition. You can dispose of it, you can sell it. That is the one and only right a tenant does not have. When you grant possession under a signed lease agreement to a tenant, they have 3 of the 4 rights of ownership, but they're not supposed to dispose of it. This means that the tenant is in control of the property, except for certain agreements that may be stated in the lease. For instance, in our lease, it states that the tenant must allow showings for rent and for sale, which means we can arrange showings if you have a property listed that is under a lease contract and has a tenant. What I want you to understand, however, which I find in my business, I get a lot of calls about we're selling this house, so the tenant has to move. The tenant may not have to move. If there is nothing in the lease that says the tenant must move if the property is sold, then the tenant has the right to remain in the property through the balance of their lease term. In other words, the lease travels with the deed. The lease is not terminated at the time the deed transfers. So as real estate licensees, if you're working with owners of investment properties, it would be a good idea for you to ask them, what is the termination date of the lease, and do you have a signed agreement with the tenant as to when they have to move if you sell it? If not, the owner can put it on the market for sale. He or she can sell it, but he may not be able to give possession to the buyer until the current lease term is up. So the lease doesn't travels with the deed. It is not terminated when the deed transfers. I'll give you an example, and this is the kind of thing we run into. This is August. Let's say we just leased a property, and the tenant's lease ends in June. Because the tenant wanted her children to have the full year in the school district this house is located in. Now it's August, September, October. The owner decides, because of some change in circumstance, he or she wants to sell the property. Absolutely can do it. Absolutely can put it on the market for rent. You can list it, no problem. But it would be very helpful to you to know what are the terms of occupancy if you should sell it. Because the tenant may say, no, I have the right to stay till June, and I'm not moving because of the school district. So normally what happens in that case is the buyer buys it subject to the lease, and maybe it's an investment property for that person and there's no problem, and if not, they will get occupancy when the tenant's lease is up. But you don't want to be surprised by that once you get a purchase and sale agreement. So if you're marketing a property that is under a written lease, it would be helpful for you to determine what can the occupancy be. Now, sometimes the buyer and the seller get together, or just the seller and the tenant, and a negotiated agreement is reached for the tenant to move. And what do you think that? How does that occur? The same way Attorney Miller said, give me $10,000 and I'll sign the quitclaim deed. Usually not that much money, but the tenant wants moving expenses or help with the additional cost of moving, whatever it may be. So you may find yourself in a position where you can negotiate for the tenant to move early so the buyer can get possession. So the lease does not end when the sale takes place, and the deed transfers to the new buyer with that subject to the lease, or unless an agreement has been made. So my goal here, my portion today of my sponsorship was to hopefully give you a tidbit of information that will help you in your marketing properties, which may be under lease. Stacy McKay, you want to come up, Stacy? She is our business development manager, and she's going to talk to you a little bit about how you might work with us. Thank you very much. Oh, sorry. Wait, it's that on?
Hi there, good afternoon. She said, I'm Stacy McKay. I handle business development. I've been with Gail for over 10 years. I actually started my real estate career with her over 30 years ago when I first started in real estate. She's been a great mentor and friend. So we manage, she said, hundreds of properties here in Central Florida. And we know many of you may actually manage properties yourself. And we like to work in conjunction with other realtors that do also manage, because you may manage in a particular area that you get a referral and you go, I don't want to go to Kissimmee because I'm in Sanford. And so that may be a really good collaborative relationship with both of us, because you also may, as we form those relationships with realtors, have properties that you manage in an area we don't. So we do like to have those collaborative relationships. In the folder, you'll see the realtor referral program that we do have that explains how we establish that relationship. We also have a way that you can just sign up for that program. Doesn't mean you're going to necessarily refer anything to us, but we do a drawing once a month for any of our new realtor partners for a $100 gift certificate, usually for like Seasons 52 or a nice restaurant. So it does behoove you to even just sign up for that program. And then you have that connection with us where it's easy to potentially refer someone that may want to have their home managed. Because we are a management company, that's what we really seek, is those relationships with management. Because as we all know right now, the market, just like the sales market is up, the rental market as well is up. There's 200 tenant leads for every one property. So inventory, as we all know, is where it's at. If we have the owner inventory, then we're going to attract those tenants. We do protect you as a realtor. So if you refer an owner to us, maybe an owner that can't sell, they really had a higher price than maybe what the market was going to bear out right now. They wanted to try that. It doesn't end up selling. They decide they want to have it managed for a year and revisit in a year selling the property. We will make sure that owner comes back to you. It's noted in our system so that if we come up on that point that the owner is saying, I don't want to renew this tenant because I'm going to sell, we look to see if a realtor referred it, and we make sure that client gets referred back to you, since you referred them and trusted us with them during that time of the management. We're also NARPM members. I would encourage you, if you are in property management or you're dabbling in property management, that you consider this organization. Just like we have the National Association of Realtors that protects us and brings us all together, has a code of ethics for realtors. NARPM is the National Association of Residential Property Managers. It also functions in the same way, but a collective group of property managers, not just in Orlando. We have an Orlando chapter, but they have a state chapter and they have a national chapter. So I would encourage you, if you are doing property management and you're not a member of NARPM, look into that, because they provide education throughout. Just like a little bit of the education Gail gave you this morning, you'll have that type of education in NARPM. And we're a BNI member, so if you happen to be a member of BNI, then you also get, BNI cred if you do the referral through BNI. So thank you so much for having us today, and please feel free to call us if you have any questions.
Great, thank you.
Yep.
Good.
Oh. Okay, thank you.
And they're BNI members. Janelle is,
Yes.
we're in BNI too.
Okay. I dropped it. Let's see if I messed it up again. Yes. Did I? Wait a minute. Let's make sure it's on. Okay. Moving on with the contract. Big part of the contract that gets overlooked, doesn't get done right, and this is scary. Probably 85% of the time, when you have an investment property, this provision and the provisions of the FAR bar contract do not get followed. And it leads to problems. It can lead to litigation. It can lead to a delayed closing and all kinds of things. When you take a listing, if it's an investment property and it's rented, just be proactive. Get from your landlord. You're going to need a copy of the lease because it requires in here. So it says if a property is subject to a lease after closing or is intended to be rented or occupied by a third party beyond the closing date, the facts and terms thereof shall be disclosed in writing by seller to the buyer with copies of written leases 5 days from the effective date. Barry, get me out of the contract. Did you get the leases? Nope. Fine. We're out. We're done. So you got to make sure that thing doesn't have a laser pointer, does it? I don't know. Well, maybe not. Oops. So make sure you do that. Then it says if buyer determines, again, in the buyer's sole discretion, that the leases and terms are not acceptable, they can terminate 5 days after receipt. So this is another bite at the apple. So when they say, get me out of it, did you get the leases? No. Okay, we're done. Tell the seller, you're in breach of contract, didn't do it. Oh, we'll give them to you. Then the always question is, well, they gave them to me. Am I still in contract? Am I not in contract? Technically, you're not, because if I sent a letter saying you didn't send it to me within 5 days, you're in breach, therefore we're terminating the contract, it's done. Okay, we're over. We're out of contract. However, sometimes they'll say, okay, well, I didn't get them within the 5 days. Then they send them. So I would consider that that could be a waiver. Now you have them. Now you look at them. You don't want this tenant, or you don't want what it was. We had this recently. There was 5 units over in Sarasota. They didn't send them. They wanted out of the contract. Turns out I asked them a question. They got 4 out of the 5. Well, what happened to the 5th? Well, they're looking for it. Okay, I'm fine. Let's terminate the contract. We're done. Hired an attorney. Wanted to keep our deposit. We said no. Of course, the attorneys are a dime a dozen these days. The interesting is over the last about the last 10, 12 years, law school applications were down 50%. I mean, 50%. Law schools are struggling to get students. Some are giving out iPads, giving out scholarships, all kinds of, because no one wants to get into them because the job market's so bad. I mean, new lawyers, no experience, they're getting hired for literally $30,000, $35,000 a year. It's really low. Now the economy's better. I just read an article last week. Law school applications are up for the first time in like 10 years. But anyhow, there's a million people out there the seller hired an attorney and said, no, you can't. Some guy right out of law school had no clue what he was talking about. We said, no, you're wrong. Here's the case law. And finally, he admitted to one of our attorneys on the phone, finally called and said, where are you going with this? You're not going to win. And finally, I've talked to him. He was like, yeah, you're right. and client wasn't happy, but our buyer got their money back. So you got to make sure you do this. Because it says, and buyer shall be refunded the deposit, thereby releasing buyer and seller. Then estoppel letters and seller's affidavit shall be provided pursuant to standard D. So a lot of times that doesn't get done. And we'll go into standard D in a second. I think I skipped over one though. Again, make sure everyone is aware of on this, the automatic 10-day extension. Unfortunately, because everything is so busy, has anyone ever had their contract got extended for 10 days because the lender didn't get the CFPB 3-day disclosure? No? Okay, we've seen it on this end. Someone says, yes, the lenders are so busy, they're not getting them out. And we had one a few months ago where they kept asking for it, they kept asking to do it, and they finally just said, look, we're too busy. We're not going to be able to process the loan. And so we're just going to not give it the 3 days before, so we just buy the extension. That's why, again, it's so important to know who your lender is. Make sure your lender, because a lot of brokers don't do it in-house. They sub it out to the end lender, and then you're at their beck and call. So be careful, automatic 10-day extension on that.
Barry, I had a situation with that because it wasn't solar here, because they had a problem with the HOA. So then the seller wanted $2,000 to do an extension.
Mm-hmm.
So then we said because of that, because it was a problem, then we got it. And then it was 13 days and then he requested for the 3 days, $2,000 more.
Well, and that's a good point about that, is a lot of times with extensions, and I have this kind of at the end of the presentation, in my opinion, extensions, I don't have a problem with them. They cost money in the circumstances. Your buyer wants it, it's a seller's market. The buyer wants an extension. I'm either going to say, okay, if I do, let's say they want to extend closing for a week, I may, if my seller agree to it, I may extend it, but I'll always put the language in that says, buyer agrees that all contingencies have been met or waived and the deposit is hereby non-refundable. So we had one last week where they wanted to do that, but then they were concerned about they were going to get more deposit, and then they're afraid they were going to not get the deposit because they thought the buyer was going to walk away. So the buyer had agreed to put $5,000 more up, but then the seller was smart and said, yeah, but so what? So if they put the money up and then they end up disputing it, I probably won't get it or I'll have to compromise. So what do we do? Because the seller was like, I'm not going to extend it and get into a fight later. So they were going back and forth, and they called me up, and I said, it's real simple. Buyer, they'd already had $3,000. I put in there, closing shall be extended to August 17th. Buyer, simultaneously with execution of this addendum, shall deposit an additional $5,000. Upon clearance of the $5,000, the total deposit of $8,000 shall immediately be released to the seller and is considered and is non-refundable. So that way our seller got his $8,000 right up front. So when the 17th comes around, if the buyer doesn't close, nothing to complain about. The seller's got his money. Now, of course, if they do close, the buyer gets the credit for the $8,000. So again, a lot of listing agents are like afraid or don't want to upset the buyer. And it's like, look, everything comes with a price these days. So if you do extensions, get a cost on. Signability. Had someone last week, this was strange. This was a really weird question. Someone that, because you guys can ask us questions. Buyer's agent writes in and says, the listing agent sent the contract back. They sent it in, cannot assign. They sent, the listing agent sent it back, crossed that out, and put may assign. So she wrote me and said, I've never had this happen before. And what are the implications? Should the buyer change it back? And I said, I've never heard of such a thing. Why would the seller want to let the buyer assign it? I don't know, but just leave it. Who cares? Who cares? And that's why I like this business. Every time you think you've heard it all, there's something new that shows up, but I don't know what the logic was. I said, don't ask her till later. But let me know why she says that, because that's just bizarre. All right. Huh?
Might want to wholesale it. If the buyer wanted to assign it.
No, the buyer didn't want to assign it. The seller, right, the buyer submitted the offer, not assignable. The seller sent it back, crossing it out and said it is assignable. Yeah, makes no sense. All right, question. What's a contingency? Well, it's something. An event which must occur prior to the other party being required to perform their contractual obligations, a right to close immediately despite contractual provisions to the contrary, or a federal constitutional right arising under the Contracts Clause, which says no state shall pass any law impairing the obligation of contracts. By the way, you know that that is a true quote out of the Constitution, but it's the wrong answer. All right, you're all right. Yep, it has to occur prior. Okay, and the other thing I always like, whenever you put in the additional terms, a contingency, I always like it to say, and if the let's say it's a contingency for the buyer, if buyer fails to notify seller in a timely manner, the contingency is automatically deemed waived. That way, if the buyer doesn't cancel, it's just waived. So I always like that language that's in there. All right, financing. It's great now, but we still have problems with this. And as we know, there is a major flaw in the contract. All right, so normal in here, let's say we put 30 days in, and then if you're the listing agent, you don't hear from the buyer, it's cash, automatically done. That's it. But here's the problem. The flaw in here is it just says, upon buyers obtaining loan financing approval, buyer shall promptly deliver written notice of such approval to the seller. So the buyer's agent can simply send an email to the listing agent, this is to notify you, my buyer has received loan approval. You as the listing agent and as the seller have no right to see a copy of the approval. It's a flaw in the contract. The other thing that it doesn't say is if you get turned down, they can just write you, dear listing agent, this is to inform you my buyer did not get approved. Give us our money back. They don't have to tell you why. They don't have to show it to you. They don't have to have anything. I'll give you an addendum that you can do that. I require that they give you a copy of the loan approval, and if it's a denial, of the denial. Unfortunately, what's happening today, people are sabotaging their own loans because they bid on multiple properties. So if I'm bidding on property A, B, and C, I all have valid contracts. My inspections are good. They know I'm credit worthy, but I decide to do his property instead of his. I can just send her an email saying I haven't been approved or I've been denied. Now, let's say let's say they use my addendum and a copy. So this is what happened. We had a buyer want to get out of the contract. We got the denial letter, and it said the denial was failure of borrower to submit tax returns. Okay, so we said, no, you're not getting your deposit back. But if we didn't have that language in there, we have no right to know and no right to see a copy. He would have gotten his deposit back. We had another one, the buyer was an LLC. They sent the denial letter and it had the person's individual name. I said, nope, the buyer did not get turned down for a loan. The principal did, but not the buyer. Seller keeps the deposit. We had another one that came back. They used my language and it said, lender unable to provide loan to borrower on terms acceptable to the borrower. So what that said was they were going to give him a loan, but the buyer didn't like the terms. Well, since it didn't specify the terms was outside of this, we presumed it was in it, we kept the deposit. So it's so important to get that these days. And you know, pre-approvals are worthless. Totally. I can get a pre-approval in 5 minutes, right? Rocket mortgage, you know, all these crazy things. they'll pre-approve anyone. It doesn't matter. All right, now the only thing you've got to be careful if you're a listing agent is if you don't get that loan approval, your seller can cancel the contract. Why would a seller want to cancel a contract? Anyone ever have that?
Better backup.
Either you have a better backup or it's usually seller's remorse of either I don't want to sell the house where you can get out of it, or what it usually is, they find out that their neighbor just put theirs under contract for more money and they think they can get more. So if you're a listing agent, on the 28th day, you have a conversation with your seller. In 2 days is the loan contingency. If we don't hear from them, it's cash, we can keep going, that's fine. But you said you really weren't, you were having second thoughts, you think we can get more money. What we can do is, you've got the 3 days after the 30th day the seller can cancel the contract, right? So she was going to buy my property for $500,000. I thought I should get $525,000. She doesn't give me the loan approval. So on day 31, we're going to send a letter. We're going to cancel it. Then I can relist it for $525,000. They get their deposit back, but we can put it back on the market. You've got to make sure you tell your seller. Most agents don't, and it can come back and bite you later. Now, the practical matter is too, you got to say to them, now some of them will tip off the other side. Hey, you're going to get me that loan approval? Oh, geez, thanks for reminding me. Got to send that cancellation over. No, we're not going to get the loan. You don't want to tip off the other side because it puts your seller at jeopardy because they'd be entitled to that deposit. So just always remember that to try to, if the seller wants more money. Talked about the pre-approvals. Oops. All right, as you know, the closing costs are broken out on here. Be careful, people are sliding things in here on other. Right, we had one recently where the cooperating broker, the buyer's agent, and the MLS was given 2.5%. The buyer's agent put in here 5% to buyer's agent. Okay? You think it's funny?
But isn't it a contract between the buyer and the seller, not the seller and the agent? Because what counts is what's on the listing, right?
Okay, it's a great argument. Let me tell you what the other side said. The buyer's agent says, there's a written contract now where the seller agreed to pay me 5%. Now, our argument back was that's a contract between the buyer and the seller, not you as the agent, so it's not binding on you. Let me tell you, this caused a major problem, major threats, major this. The buyer's agent, I'm turning into the Florida bar for practicing law without a license. You should see the email she sent. My legal opinion, my research, this case, this, and she's writing to me saying, you will do this, you will do that. She's telling me what to do. By the way, I never answered her once because my opinion was I don't work for her. I'm not telling her stuff to do. So they actually ended up the buyer ended up hiring a law firm that were threatened to put a list pendants and file a specific performance on it. So, and my listing agent was like, well, there's no way I'm paying it. And I said, shame on you. Shame on you. Because let me tell you what you did. You got the email, you forwarded it to your client, they signed it electronically and sent it back. Yep. You never looked at it, did you? Nope. I said, you know something? You should give up your commission. You should pay that agent because I think the buyer's agent was wrong. But I'm like, you should, what you did is you're lazy. You didn't look at it and just shame on you. I can't tell you how many listing agents don't look at the contracts. You got to look at it, either print them out with your highlighter or put it on the screen. And even in PDF, you can make little comment notes right on it electronically. You got to do that. You got to look at them because I can tell you right now, the perfect contract, what percentage of contracts do you think we get in that are 100% done right.
25.
Probably like 25% of them. 75% of them have mistakes. Some of them are, most of them aren't major, but most of them is because nobody looks at them. So you got to make sure you do that. And again, errors and omissions policies are skyrocketing. Those of you who are brokers know that. I have some brokers in town here that cannot get insurance now because they've had too many claims. I have friends that work for insurance companies as attorneys. They've never been busier in their life. Most of them don't go to court. They either go to arbitration or they get settled, but they're paying out record numbers. So be real careful. People sneak stuff in there and the others all the time. Now that's the new trend. The title search, again, it says in there, if there's financing, it's 15 days. Be careful. If your buyer's cash, you're only entitled to get it 5 days prior to closing. So you want to change that and make it 15. We just had one where they didn't give them the title commitment till the day of closing, and then there was problems and it couldn't close. So you got to make sure you get that up there. Oops. Don't forget, on the regular contract, you've got the difference in there is the 1.5 for general repairs, 1.5 for WDO, and the cost of permits. All right, so let's get this misbelief out there. Regular contract, the seller does have the obligation to close out the permits up to whatever is in here. Now let's talk about the real world. The real world is the as is. The seller has no obligation to close out permits. None. The only thing they have the obligation to do is to cooperate with the buyer and let them sign it. So if you look on, because this comes up so much. So if you look at paragraph 12C, line 258 of the handout, so it says, if buyer's inspection of the property identifies open or needed building permits. If buyer's inspection, therefore, who needs to look and see if there's open permits? The buyer, not the seller. So if they do it, then seller shall promptly deliver to buyer all plans, written documents, or other information seller's possession, knowledge, or control relating to the improvements to the property which are subject to the open or needed permits, and shall promptly cooperate in good faith with the buyer's efforts to obtain estimates of repairs or other work necessary to resolve such permit issues. Seller's obligations to cooperate shall include seller's execution of necessary authorizations, consents, and other documents necessary for buyer to conduct inspections and have estimates of such repairs or work prepared. But in fulfilling such obligation, seller shall not be required to expend or become obligated to spend any money. So they don't. Now, when we do municipal lien searches, we do not include open permits because it's not an issue. First of all, it's not an issue for title. You can build a house without a permit and we can insure it. It is nothing because we insure the right title and interest in the property, not in the building. So again, from a buyer's perspective, hop online and look. Personally, I would only use an inspector who I had an arrangement with that he checks the permit status before he goes out. Because if there's an open permit, let's say it's for a roof repair, if it's open, well, during the inspection, I want him to see if it was done or not. If it was done, he'll say, yeah, it was done. It looks like it was right. Then you can then do an addendum requiring the seller to do it if they agree. But just make sure you know that it's not required.
I have a question about that, because it happens to me a lot. So if the title company finds an open permit a few days before closing,
Let me just stop right there. I won't find them because I'm not looking.
but some title companies
Yeah.
have the buyers sign a hold harmless for open permits. So
Well, they just, yeah, they have sign a hold harmless for anything, yeah.
So if they find the open permit right before closing, after the inspection period, can the buyer back out if this, no?
Absolutely not. Yeah, they can back out and lose their deposit.
Okay.
Yes. And that's what happens all the time, is because the title companies that do the open permits, they don't get them to you during the inspection period. They get them to you later,
Yeah, later
and then
on.
it's too late. No, bad agent. Bad agents that do that. You get yourself in jeopardy. And I have had that happen, and the buyer walks and they lose their deposit, and you know what they do? They go right up to the agent and go, I'd like that check for $3,000. For what? You messed up. You never told me that I had to do that. You didn't tell me that it's in there. Now, of course, from an agent's perspective, they should say, I'm not an attorney. I wasn't supposed to tell you that. You should have hired, this is the biggest purchase of your life. You should have hired an attorney before you got into this. Now, the agent ended up writing a check because they were going to make their life miserable. But again, this is real complicated stuff, folks. Every agent should tell their people at the beginning, this is the biggest purchase of your life. You should get an attorney. You'll see our flyer that's in here. A lot of my agents, what they do is they tell them that. And if they say, no, I don't want one, they take our flyer and they write declined on it and they make their buyer sign it. So later on, when that comes up, they go, I told you to get an attorney. You elected not to. I don't interpret the contract for you. I don't have a license to interpret it. Same thing is when, if you do have a buyer or seller that reads and goes, what does this mean? What does this mean when it says a term in here? You cannot legally explain it to them. That would be giving legal advice. That would be interpreting the contract. Because if you interpret it wrong or you give them the wrong thing, they'll sue you. So you just got to be there. What you got to do is buy and sell, list, sell property, the rest of the stuff. Now, it's interesting because in some states, like for example, New York State, realtors do not fill out contracts. They won't even fill out a blank form. Will not do it. A lot of states are like that. So we're very different here. Whoops. FERPTA. FERPTA is a problem. All right. When you're taking a listing, don't assume they're a U.S. citizen. Ask. We have a lot of Canadians that you think they're Americans. You have different people. Ask. If they are, head on right in the beginning. We have two vendors that we use that are good for FERPTA to get the exemption certificates, and it's very inexpensive. It's like under $500. Get them hooked up with them, get it done, make it easy. Now, another big thing that comes up now is that we've been seeing is in the MLS, they put, if it's a house under 300,000, you'll see in the realtor remarks, buyer will be required to sign FERPTA exemption. So I have buyer's agents that call up, do I have to do this? No, you don't. Can they do this? Yes, they can, if they put it in the terms of the contract. So we had this happen. It was in the MLS. They went to closing. Buyer's like, I don't feel comfortable signing this. I get the call. Do they have to sign it? The answer is no. Why? The listing agent said, it's right there in the MLS. Buyer, you have to do it. I told the listing agent, the MLS is not binding on a buyer. Where does your buyer, does any buyer ever sign something that says, I hereby agree to all terms and conditions, statements, but that's in the MLS? No. So that buyer said, that's an agreement between the agents. Agents, you can sign that affidavit. I'm not signing it. And I said, you're within your rights. And the seller said, well, I'm not selling the property because it's FERPTA and I'm not doing the withholding. And I said, seller, you'll be in breach of contract. Now, if they put in the contract, buyer shall at closing sign the affidavit, go on, Now, it's okay for them, but people say, is it okay to sign it? Like, well, as long as you meet the requirements. If it's under $300,000 and it is intended to be your primary residence, you can. It's not a problem. So getting to know FERPTA is good. and it's not a real big deal. You just go do it. And we're having more and more and more of it, especially Chinese buyers. I'm dealing with a group right now. They're actually building 100 homes, a Chinese developer, to all Chinese buyers for short-term rentals. South Americans are coming up more to the Orlando area because it's more affordable than South Florida. In the UK, investors are coming back again too. So be real careful of it and just get it taken care of. And if you need help, just give us a call.
I've got one question on that. If the seller is a corporation, like a U.S. corporation with a federal ID number, does PERFA still apply, or would that?
The answer is maybe on it. A lot of times, if it is a U.S. A Florida LLC, a lot of times it will be exempt. A lot of times. All right, we talked about the as is. Of course, it's buyer's sole discretion. I get another question. Hey Barry, I want to get out of the contract. Like buyer says they want to get on the contract, but we haven't done the inspection yet. Do we have to go hire that inspector to do the inspection and then we can cancel? The answer is no. It does not say in here, okay? It just says buyer shall desire, in buyer's sole discretion, the buyer's not acceptable. Okay, it says during the inspection period. There's nothing in here that actually obligates you to hire an inspection because some people self-inspect. I mean, they decide to do it. And then the other thing is, if you're using the regular contract, the regular one, don't forget there is no automatic right to cancel. It doesn't have that language. It's left blank 1.5. And this happened. Let's say it's $10,000. You do your inspections, you get your estimates, it's $9,700 to fix it. And you're like, oh, great, we're going forward. And the buyer says, I just don't have a good feeling about this. I think the 9,700 isn't right, or I think this is, I don't want the property anymore. Let's cancel. They lose their deposit. All right, but use addendum L. Addendum L mirrors the as is. So if you use the regular contract and use addendum L says, despite what it says in the contract, you can get out for whatever reason in the buyer's sole discretion. Okay, so don't forget to do that. I had an agent once that forgot that, and then this guy wanted to get out, and it was a mess. Title evidence. A lot of people don't realize this. Two things. By the way, how many listing agents give the prior owner's policy and the survey to the buyer's agent with the accepted contract? Nobody. You're all in breach of contract. Barry, get me out of the contract. Did you get the owner's policy and the prior survey? No. Okay. It does require that you give that. It's back in paragraph 9. If you look on on line 149 of the contract, if seller has an owner's policy of title insurance covering the real property, a copy shall be furnished to the buyer and closing agent within 5 days of the effective date. It says that later on about the survey. Now, realistically, would a judge probably let you out of that? Probably not. But if it was one of 8 things, probably will. So I always recommend, again, you get them at your listing. If your client says they don't have them, when you send over your contract, your buyer's agent, close, please sign the fully executed contract. Congratulations. Attach, please find, or my seller has made a due diligence search for their prior owners and survey and could not locate it. Therefore, we cannot provide it. All right, just do that. You're safe. You're within the contract bounds. One less thing they could try to get you on. The other thing is a lot of title companies do not send out title commitments these days. They're required to do so. You got to keep on them. Now, a lot of them don't order them until after inspection, so then you don't have the benefit. Let me tell you one thing we do. First of all, we'll give you a free title search when you list your property. So why not just do it then we know it is. As soon as you go under contract, we do a quick update, it's out. if you give us your contract, and we haven't done one already, we do a municipal lien search and the title search as soon as we get the contract in. Usually our turnaround time is 3 to 5 business days, and then we send them out to everyone. But we also send them out with the B2 exceptions, because the contract says you've got to provide the B2 exceptions. It's another way to get out of the contract. Now, do we expect you to read them? No. But we expect you to send them to your buyer and your seller to comply with the terms of the contract. So the title commitment shows what's going to be discharged, make sure there's marketable title, and says that the standards of the Florida bar are adopted in doing that. The buyer has 5 days to examine it. Has anyone had a buyer examine the title commitment? No. If they have an attorney, they do. Because if we represent the buyer, we then send a letter on behalf of the buyer to the company, to this title company, what's called a title objection letter. And what we say is we expect all the things on Schedule A to be complied with. And then on Schedule B, we get them to delete the standard exceptions. So everyone doesn't realize this. There's a standard exception. Exception number 1 is the gap. It says if anything is recorded from the time the deed gets signed to when it gets recorded. So let's say closing was last Friday and the deed gets recorded today. If yesterday the seller didn't pay the roofer $10,000 and the roofer put a lien on it, no title insurance coverage for the buyer. Your SOL. That's shocking, isn't it? Can you imagine if you're the buyer's agent explaining to them, sorry, you're going to have to pay that $10,000 or you're going to foreclose on your house. Okay, that standard exception is on there. Now, we always delete it. Always, always, always. My feeling is if I can provide a better policy for no extra cost, I do it. But most title companies don't. So when we're representing a buyer, we get those taken care of. And we read all those exceptions and make sure they apply. If they don't apply, we get them taken off. There's something always on there called a Chapter 159. That's for municipal liens. All the other title companies will leave them on there. So a week after closing, 2 weeks after closing, you get a letter from the utility company, the public utility company your buyer does that they owe money. There's no coverage. So all title policies are not the same. You got to be careful. It's another reason why when you send your commitment to your buyer, encloses the title commitment and the exceptions, please review this carefully. I again would suggest that you seek legal counsel to assist you in interpreting and explaining this document. All right, the 18D, if we want to look at that, that's the other one that we were talking about. That's what you have in investment property. So that's what the lease is. On or before 10 days prior, seller. You got to give the nature of the tenancy, the duration, the rent, and if they misrepresent anything, they can get out of it. This is where they're entitled to an estoppel letter. You know how we get estoppel letters from HOAs that say, you know, the seller is in good standing, or no, they owe $200. The estoppel letter is the same thing. It's the tenant signs it that says, I have a valid lease. The seller is not in breach of the lease. This is how much I pay in rent. I have no advance rent. This is how much my deposit. So I had an agent that just ignored everything. After closing, they closed in October. They got a call in December 1st from the title company that said, you need to write a check to the seller because the money that was actually paid in November was for October's rent. And so you need to give that money to the seller. They called me up and said, do you have to do that? I said, why would you have to do that? Did you get an estoppel letter? No. Did you get a credit for the deposits? No. I said, do you know that there was 4 units and there was like $1,000 a piece security deposits? I said, you know that your buyer now has to pay that $4,000. Oh, no, they don't. They didn't get it. The seller got the money. The buyer stands in the shoes of the seller, all obligations. So now that buyer has to pay those deposits. And I told that agent, I said, you know something, you should write a check for $4,000. Well, how am I supposed to know? I said, do you have a license? You have a license. You should know that. So you got to be real careful on rentals. Now, where do you get the estoppel? Oh, I'll find a form on the internet. No, you won't, because then you're going to be practicing law. So you got to be careful. Some title companies will do them, most of them will not. So you got to be real careful in there. The biggest thing is advance rent. Because I had a guy once where he bought a property, didn't get this, goes to the tenant, and the tenant says, I paid 6 months in advance. It's like, what? Oh yeah, here's my receipt. I got the landlord to sign a receipt. That buyer couldn't get any more rent. So what ended up happening, we found out, is the tenant had some problems, and the landlord said, you can stay if you give me 6 months, or what it was, 4 or 6 months in advance. They did. The seller didn't disclose it. They're out the money. Time. This always comes up. Calendar days will be used in computing time periods. Time is of the essence. That means we got to be strict. Other than times for acceptance, because we had that delivery, in the effective date is set forth in paragraph 3. Any time periods for dates specified in the contract, whether pre-printed, handwritten, typewritten, or inserted, shall then occur on Saturday, Sunday, or legal holidays. You go to the next business day. And I always get the question, is that till 5 o'clock? It doesn't say next business day at 5, so it's the next business day at midnight. All right, so just be careful of that too. That comes up a lot.
It does say, shall extend at 5 p.m.
Oh, I'm sorry, that's the one till 3 p.m. Sorry.
5 p.m.
So extend to 5 p.m. Okay, I'm sorry. My question was, if it's not one of those, and let's just say the last day was on Tuesday, let's say the last day was today on the inspection period. They always say, do I have till 5 o'clock? No, you have till midnight. So it's only when it's extended. Thanks for pointing that out. The conveyance down here. Remember when I said, okay, personal property shall. Now there it says at the request of buyer be transferred by absolute bill of sale. But here's the thing, with warranty of title. That's important. Because I had once where this was brought up where the buyer's agent asked for it. The title company said no, they wouldn't do it. The listing agent decided to play lawyer, did one off the internet. Luckily, the buyer's agent sent it over to me and I said no. They put on there as is, where is, with no warranties. I said no. We have to have warranties. Otherwise, what happens if that washer and dryer is the neighbors? There's no recourse against them. So you have to have warranties of title. All right, the addendums, make sure you check them off and use them because they're very important that we got to do. The condo rider, we do a whole separate class on riders. The most important ones, as we said, is the homeowners association. Be aware that if you do not do the addendum or it's inaccurate, the contract is voidable by the buyer. So if you put on there the dues are $100 and it's $102, the buyer can walk. So you want to make sure they're accurate. I always tell you that when you take your listing, call the management company and they're going to go, we can't release any information. I don't want anything about the particular information. In general, are your dues $102 a month? Well, I can't confirm that. I'm not asking if they're current or not. Are they 102? Oh, okay, yes. Or they'll say, well, no, as a matter of fact, they went up to 105. Great, thanks. Any special assessments coming up? Any pending the threatened lawsuits? Become friends with the property manager. And then you'll make sure all of that's accurate. Appraisal contingencies, please, people, use this. It's written beautifully. Never write the word contingent, never write the word appraisal in the additional terms. Never want to see it there. If you write the word appraisal, contingency, in additional terms, you're not doing it right. I guarantee you're not doing it right. Just use the appraisal contingency. It says what you need to do, and it requires a copy to go to the seller if it turns out lower. All right, basis for cancellation. As I said, HOA and COA addendums not right. Fraud, misrepresentation, concealment. Disclose, 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 right? It's the biggest way to get out of a contract. Financing, capacity we talked about, the whole lease situation we talked about, failure to maintain the property. Just had one yesterday. The guy came in and said, we did the walkthrough. When I saw the place, it was empty. He put his cousin in the property and it was trashed. Trashed. The microwave was ripped out of the wall. It was filthy in there. Listing agent said, the client's out of town. They're not going to do anything. That was one problem. Second problem is the guy never got his title. This cash deal never got his title commitment. That was the second reason. But here's the bad thing. The agent's broker advised him, well, just tell them that since you didn't get the commitment, you're not closing. So he called the title company and told them that. I said, you need to tell your broker, that broker, to write you a check now, because they're refusing to give him his deposit back because he didn't close. I said, did you do anything in writing? No. He said, the broker just advised me to call the title company and say, since I didn't get my title commitment 5 days in advance, I'm not going to close. Okay, that's not a legal reason. So, and I know this broker, you should know. Failure to close. We keep seeing this. People just don't show up. They don't show up. Unsatisfactory inspection, failed appraisal. So those are, you know, the most typical ones of why they do that. Loss of deposit. All right. Failure to timely cancel. Remember, folks, that if you get an extension, make sure to address the deposit of what's going on. Again, if someone, in my opinion, wants an extension, your money goes hard. Why not? Don't be afraid to ask. Failure to extend. If you extend the inspection, consider extending it. Oh, that's the other thing is, don't forget, because if you, sometimes you extend the inspection, but then you run short on your time for your loan approval. So always ask your client, that say they want another 5 days for inspection. What's going on? Are you going to need more time for your loan? Because it's going to be easier to ask for an extension for both of these at the same time than go for one and then go back another. The seller's going to go, what's going on here? You know, next you're going to want to extend the closing. And obviously the loan approval. There are still agents out there that are like, oh, this is Florida. It's the law. If you don't get a loan, you get your money back. I love it, because when they usually I think they teach that in South Florida real estate schools, because every time I get someone from Miami, that's what they say. And I'm like, no, maybe in Miami you do it that way. Here we don't. Here we follow the contract. So this is coming up all the time. Johnson v. Davis is the Florida Supreme Court case from 1986 that said caveat emptor is gone. No more buyer beware. If you know it, you've got to say it. And you as an agent, if you know it, you got to say it, because you're transactional agents. If you know it, you've got to do it. And don't do the thing is, don't tell you, oh, I don't want to hear about it. Don't say that. Don't do it. Be transparent. It's not worth your license. Okay, the other thing that's in your packet in here is that timeline. So again, what I suggest you do, and if you want this in electronic form, let us know. First of all, there's some, go to your materials there. Section 2 is the loan approval language that I told you about on the addendums. Okay, I really want to go over this, because you should make this, or ask your broker to make this part of, keep flipping, to make this part of your standard agreement. Is everyone there? It's the one with our letterhead on it. All right, Roman numeral 2. Everyone there? Oh, we got more to go. There we go. All right. Buyer shall provide written verification from the mortgage broker or lender of the loan approval in accordance with the terms set forth in this contract. Okay, make sure it's 30 years, the interest rate, everything in there, the amount. If buyer fails to obtain loan approval within the time set forth and thereby terminates this contract, buyer shall provide written verification of same and the reason for such denial. because some people have done versions of this and they just say, got to give them a copy of the denial, denied, doesn't say why. So this way you get a reason to, and that way, if your seller's entitled to do it. Now, people say, well, I'm the buyer's agent. This isn't really nice for me to do. Okay, if I'm the buyer's agent, I'd be like, yeah, I want to see that loan approval. I want to make sure this buyer's legitimate. So what happens if you're the buyer's agent? Let's say you're the buyer's agent. I've got someone different. If you're the buyer's agent, I'm the buyer. You spend a lot of time with me, $500,000 home. I just write you and say, good news. Please let the listing agent know I'm approved for my loan. I have my loan approval. You're going to go, great. So what happens when you say to me, well, who's your lender? And I say, none of your business. It is none of your business. But if I have this, even as the buyer's agent, then I can see who it is. So that language is real important. The closing escrow agent, by the way, in today's market, hold on a second. I have a lot of buyer's agent because of all the nonsense going on out there. The buyer's agent will put that closing agent, escrow agent language in there so that the buyer can control the closing. I have a lot of my buyer's agents that use that. Okay, the next thing on here is the timeline. So that's the thing you should do. So once it gets accepted, whether you're the buyer or the seller, fill out the time date, send it to the other agent, and just say, hey, I'm really looking forward to working with you to make this transaction smooth and transparent. I've gone ahead and marked all the dates in the transaction. Please confirm that you've received this and that you agree with the timeline. Because I don't want them to say, well, no, it wasn't, the effective date's yesterday, not today. So you all get on the same page, because we've got to raise the level of the profession. You guys are worse rated now than lawyers. I hate to say it, you're rated less than used car salesmen now, okay? And look, there's good agents, there's bad agents. We all got to try to make everybody good agents. This is the way you get rid of the gotcha and puts everyone on the same page so it does go through. Because what is it about? It's not about the commission, guys. It's about your clients. Same thing with us. We have ethical obligations to our clients, so do you. So do this. It makes it real easy. You can make copies of this. We have it in electronic format. Okay, sir, you had a question.
Regarding the loan approval, can you go as far as saying a reason for such denial from underwriting? Does any broker can just put in a sentence of?
Well, they have to put the reason, and that comes from the lender, because the denial letter will come from the lender of the reason. So, it'll be, inadequate income, whatever it is, lack of, whatever the reason is. Yeah.
I just was wondering if you could add in there from underwriting.
Well, why do you need that? Who else is it going to come from?
Because sometimes the general lender can just write in what the buyer, they're working with the buyer for whatever reason. If it comes directly from underwriting, then you know.
Okay, so then you're going to get it and you're going to go, this isn't an underwriter. It's the branch manager. It's the deposit. I mean, it's assumed if that's coming on letterhead from ABC Mortgage or Bank of America, it's someone with authority and they're giving you the reason. If it says failure to provide tax returns or inadequate income, it doesn't matter whether the underwriter signs it, because if you do that, some lenders, the underwriters may say, we don't have authority to sign those. That's done by the branch manager. So yeah, you don't want to give them a reason to get to know. All right, so lots and lots and lots of stuff. Do it easy, do it right. If you need help, we're here to help you for it. The other thing I just want to mention before we get into questions, for those of you guys that use us, I want to thank you all for your business. We really appreciate it, because without you, we wouldn't be here and grow and put these classes on. For those of you that might be new, we look forward to maybe doing business with you. And again, one of the big things is that we built this on is the attorneys that myself and David and Robert. And one of those nice things we have is that buyer's rep. By the way, it's $9.95. One of the things we'll do for you is, you're all busy today. How much time would you save if you didn't have to write contracts and go back and forth with contracts? When that buyer hires us, we do the contract. You present it, And when it comes back with changes, you don't have to look at it then. You don't have to make sure the blanks are done. That's our job. And that's what we do that. So we had an agent say, well, that's great, but not going to work. I said, why not? Go, it's done on Saturdays and Sundays. You're not there. We go, yeah, we are. They're like, what? So what we do is if the client retains us in advance, one of the three of us is on duty that weekend. So what happened about a couple of months ago is agent emails me Saturday morning, 10 o'clock, get on the phone. Cheryl, what's going on? Found the perfect house. That's great. We start talking. We do it. She goes, what do I do now? I go, present the offer. She goes, what offer? I go, look in your inbox. She goes, what? I said, well, why do you think I was asking you all those questions? It's done. It's in your inbox. She goes, well, what are we going to do tomorrow? I go, I don't know. Go sell some more property. She goes, well, no, when they counter. I said the same thing. Either just call us or email us back, and then we'll deal with whatever the counter is. She goes, it's too easy. I go, exactly. Now go sell some more property, make some more money. So it's a great way to save time, and it reduces your liability, gives that comfort, the client a comfort level. So anywhere on the trend in towards the transaction where it goes back and forth, especially if you have clients buying new homes, that contract's 60 pages long. There's a lot of stuff in there they should be aware of. Can you change it? No, but at least you can let the buyer know so they won't get mad later. They can say, well, I didn't realize that. And by the way, on some builders contracts, you can't change it, but I've gotten addendums done that are favorable to our customer. And then don't forget on new homes, the buyer pays the title, so the buyer gets to choose. We're usually $500 to $700 cheaper than the builders because they use it for a profit center. Okay, questions?
So do we represent sellers?
Sorry?
Do we represent sellers as well?
Yes, we do the same thing on the sellers. So it's the seller side, we represent the seller, and they get the contract in. We'll review the contract and do all that. Now, on the buyer's side too, we do that buyer objection letter and always get them a better title policy too. All right, any other questions? Yeah. Yeah, it's a flat fee of $9.95, and we'll either review or write the contract, do the title objection letter, review all the closing docs. Usually we save them some money on the title company that's trying to charge them some junk fees they shouldn't. We do everything except we don't go to closing with them because we'll review all the documents in advance.
So we'll represent the seller. Do you do a bundle like the title insurance and
Yep.
the representation?
Yep. Yep.
So what do you feel about that? It depends, or?
Yeah. Yeah.
Depends on the title insurance?
Well, it kind of depends on what the situation is on it. All right, anyone down at the branches? Anyone got questions? Oh, all right, now then.
Yes.
All right, thanks, Nate. The last thing is we're starting to do our calendar, believe it or not, for next year. So if anyone has suggestions for classes on particular subjects, let us know. Don't forget, fill out your form for your CE credits and see Janelle here or one of the representatives in the branch. And so you can get your 2-hour CE credit. And I'll stick around. Anyone has any questions? And out the branches, any questions, feel free to email or call.
Thank you. So for the oversight